The controversies surrounding the call to disbar Aloy Ejimakor for his participation in the protest organized by Omoyele Sowore presents a layered debate, legal, political, and social. On one side are voices arguing that Ejimakor's involvement was against professional ethics and compromised the legal process. On the other are those defending his right to protest, citing constitutional freedoms and the lawyer's broader role in society. Please like and subscribe to this channel for more interesting stories like this. Below, I analyze both sets of arguments and reflect on the wider implications. Those who are supporting that Ejimakor should be punished stress that his participation in the protest undermines the integrity of the legal profession and the administration of justice. For instance, the organization Center Against Injustice and Domestic Violence has formally urged the Nigerian Bar Association, NBA, to discipline Ejimakor for allegedly violating the Rules of Professional Conduct for Legal Practitioners 2023, especially Rule 33, which prohibits a lawyer involved in ongoing litigation from making extrajudicial statements capable of influencing public or judicial perception. Please like and subscribe to this channel for more interesting stories like this.
Now, let me continue with the gist. The people argue that Ejimakor is a counsel to Nnamdi Kanu, leader of the indigenous people of Biafra, whose trial for treasonable felony remains before a competent court. By participating in a public protest alongside Sowore, calling for Kanu's release, Ejimakor may have engaged in extra-legal tactics intended to influence public opinion and possibly the judicial process itself. The presidential aide, Bayo Onanuga, described this as a lawyer resorting to extra-legal tactics rather than focusing on defense strategy. The concern is that such conduct breaches the duty of a lawyer to preserve the integrity of the court, avoid prejudicing ongoing operations of justice, and maintain the profession's reputation for impartiality and restraint. Kind of, the statement emphasizes the need for discipline, restraint, and respect for the sanctity of judicial proceedings. Please like and subscribe to this channel for more interesting stories like this. The fears are that allowing a lawyer in a high-profile case to join street protests could set a precedent. Lawyers might then engage in activism during active litigation, potentially causing confusion between advocacy in court and extrajudicial public agitation. The presidency's position is that the protest was a shambolic display, and Ejimakor should have known better. In summary, this group argues that while lawyers have rights as citizens, their professional role imposes stricter constraints, especially where an ongoing case exists. Public protest in such a context can compromise the fairness, appearance of fairness, and due process of the legal system. Please like and subscribe to this channel for more interesting stories like this.
On the other side are lawyers and commentators who reject the call for disbarment, arguing that the actions of Ejimakor do not amount to professional misconduct and that his participation reflects constitutional rights and a broader conception of the lawyer's role in society. There is no specific provision in the RPC or the Legal Practitioners Disciplinary Committee (LPDC) rules that outrightly forbids a lawyer from participating in a peaceful protest to ask or demand the release of his client. As noted by one practitioner, I am not aware of any law or ethical rule in the legal profession that prohibits a legal practitioner or a counsel on record from taking part in a peaceful demonstration to ask or demand the release of his client. The protest was not directly targeted at the court nor meant to influence the judicial officers. Its thrust was political and social, demanding Kanu's release and raising broader human rights concerns rather than becoming part of the trial record. Thus, some argue the sub judice principle does not automatically prohibit the lawyer's participation. Please like and subscribe to this channel for more interesting stories. From a human rights perspective, the law recognizes the right to peaceful assembly and protest. Lawyers, as citizens and as defenders of rights, may have dual roles: to appear in court and to use public platforms for rights advocacy when appropriate. In that sense, the protest participation can be seen as consistent with the lawyer's duty to uphold justice, especially where the matter touches fundamental rights. Socially, the call to disbar a lawyer for exercising his civic rights could be seen as a chilling expression and arguably risks placing the legal profession in a narrow frame, excluding public advocacy or political participation. Critics warn against professionalizing lawyers to the point where their civic agency is curtailed. Please like and subscribe to this channel for more interesting stories. Politically, some argue that the reaction to this protest is symptomatic of selective regulation. Lawyers representing unpopular clients or causes faced stricter scrutiny. The fact that a lawyer in a highly charged political security case is being targeted may raise concerns of intimidation or instrumental use of regulatory mechanisms to suppress dissent. However, those who are not supporting the punishment argue that the lawyer's conduct, while perhaps unconventional, does not warrant disbarment. Instead, the focus should be on whether the actual prejudice to the judicial process occurred, which they argue remains unproven. Please like and subscribe to this channel for more interesting stories.
Going further, this analysis will look at the legal, political, and social implications of calls for the disbarment of Ejimakor. First is the legal implications. If the NBA or LPDC were to formally discipline or disbar Ejimakor, it would raise significant legal questions about the boundary between a lawyer's professional role and his or her civic rights. It would force the legal profession in Nigeria to clarify what constitutes professional misconduct in the context of public protest. To what extent is the principle of sub judice or extrajudicial comment applicable to street protest as opposed to media statements or court-directed communications? How to balance the lawyer's duty to the client and to the court with the lawyer's duty to society, especially where fundamental rights and public interest are involved. Please like and subscribe to this channel for more interesting stories like this. A decision against Ejimakor may set precedent that discourages lawyers from public human rights work, particularly in politically charged cases. On the other hand, a decision in his favor, no sanction, may open the door for lawyers to take more active public advocacy roles, even when tied to ongoing litigation, raising risks of undue public pressure on legal outcomes.
Also, from the political angle, the protest was organized by Omoyele Sowore, a human rights activist and politician, and called for the release of Nnamdi Kanu, a charismatic leader whose case is centered around issues of ethnopolitics and national security. The attempt to punish Ejimakor for his participation may be seen as part of a larger dynamic: the regulation of dissent, the governance of protest, and the space for civil society activism. Please like and subscribe to this channel for more interesting stories like this. If lawyers are barred from such participation, the professional class may become more insular and less able to engage in public interest causes. Conversely, when lawyers publicly align with politically sensitive causes while functioning as defense counsel, it raises risks of blowback from the state, or a perception, fair or not, of political partisanship. From a social perspective, the case raises the question: what role should lawyers play in public life? Are they purely courtroom advocates, or are they also civic actors? In Nigeria's context, where human rights, freedom of expression, protest rights, and government accountability remain contested, this debate is especially salient. Please like and subscribe to this channel for more interesting stories like this. If the professional community moves to isolate lawyers who take public roles in protest, it may diminish the profession's social legitimacy as part of the broader justice ecosystem. At the same time, society must grapple with concerns about rule of law, fairness, and the perception of impartiality in high-profile trials. If lawyers are seen publicly campaigning or canvassing for judicial outcomes, public confidence in judicial impartiality could erode. Please like and subscribe to this channel for more interesting stories like this. Reflecting on both sides, I find that the arguments against automatic disbarment carry more weight. At the same time, the concerns raised by the sanction advocates are also legitimate. The key point here is whether Ejimakor's participation actually prejudiced the judicial process or simply represented his civic choice to support a cause aligned with his client's rights. I believe that lawyers retain a right and perhaps a duty to engage in public advocacy, particularly when human rights and fundamental freedoms are at stake. In a democracy, those voices help hold institutions to account. However, I also recognize that lawyers must navigate the fine line between advocacy and respect for the court's independence. Please, like and subscribe to this channel for more interesting stories like this. In this case, the protest was public, but not clearly targeted at influencing the court, and no specific rule appears to prohibit lawyers from participating in peaceful demonstrations as citizens. That suggests that sanction, let alone disbarment, would be disproportionate unless clear evidence emerges of misconduct or prejudice. However, I would also argue that lawyers in high-profile cases should exercise heightened caution. They should ensure their public advocacy does not compromise client confidentiality, is not used as a tool for undue public pressure, and does not generate a reasonable appearance of undermining the judicial process. In the future, the NBA might consider issuing more guidance on the intersection between public protest and litigation. Please like and subscribe to this channel for more interesting stories like this.